Thank you, Chairman Westerman and Ranking Member Huffman, for the opportunity to testify today. I am the J.B. and Maurice Shapiro Professor of Law at the George Washington University Law School. I base both my oral and written testimony, which reflect only my own views, on my experience teaching environmental law for nearly 45 years, and on my scholarship on NEPA, which includes being the lead co-author on the leading legal treatise on the statute. I will speak today to the SPEED Act. Congress enacted NEPA on a bipartisan basis in 1970 to prevent avoidable but irreversible environmental mistakes. It was premised on the sound rationale that it's foolish to proceed in darkness when it's possible to discover foreseeable harms in time to avoid them, instead of later engaging in hand-wringing about disasters that could have been foreseen or not because of short-sightedness, impatience, and lack of concern about environmental risks. The SPEED Act seems to forget that origin story. But even if Congress is intent on revising NEPA, this is the wrong time to do it. Congress made major changes in NEPA in the Fiscal Responsibility Act of 2023, and the Supreme Court recently shifted judicial review toward greater deference to agencies in their NEPA preparations. It would make more sense to step back to evaluate the impact of these developments before rewriting the statute again, especially in the fashion called for by this bill. The SPEED Act does not streamline NEPA. Instead, it strips NEPA of what makes it work. It leaves the statute on the books so that it appears to be a functioning environmental assessment regime when, in fact, it hollows it out. It reduces incentives to develop information on environmental effects by all stakeholders and enables agencies to proceed in darkness, even when it's possible to learn about foreseeable harms in time to avoid them. The inevitable consequence of this legislation would be the acceleration of inadequately vetted projects and an increase in the risk of unforeseen, unintended, and adverse impacts. My written testimony centers on 4 categories of problematic provisions in the SPEED Act, which I described there in more detail than I'm able to do this morning. First, the bill narrows the scope of NEPA's application by allowing government agencies to avoid NEPA procedures entirely, notwithstanding their environmentally damaging potential. An example is the provision redefining the term major federal action to exclude loans, grants, or other forms of federal financial assistance unless the federal agency providing that assistance exercises complete control and responsibility over the effect of the action. The retention by non-governmental actors of artificially created discretion over minor aspects of project implementation shouldn't matter. Another objectionable provision would require an agency's purpose and needs statement to meet a private project proponent's goals. This turns NEPA on its head by displacing considerations of whether a project promotes the public interest with whether it satisfies the narrow, self-interested objectives of private project proponents. Second, the SPEED Act allows agencies to make their NEPA determinations in ignorance by limiting public input into the NEPA process and allowing agencies to ignore relative information made available to them by informed stakeholders. Telling agencies to ignore new scientific data once an application for a pedal permit is filed is senseless. Doing so not only punishes communities and experts who invest in generating the information, but also rewards decision-making in ignorance, a result directly contrary to NEPA's goals. Until an agency receives an application to approve private development, it has little reason to undertake research. The application describes the parameters of the project, revealing for the first time the kinds of environmental risks posed by agency approval. That's precisely the time when agencies should be engaged in gathering information about the environmental risks posed by a project. Third, the SPEED Act would block access to the courts by those adversely affected by decision-making that occurs in violation of NEPA's procedural requirements. For example, it would block challenges to the adoption of categorical exclusions, which authorize avoidance of all NEPA analysis. Fourth, the SPEED Act would shackle courts in the kinds of relief they can provide, even when they do find statutory violations. Most disturbingly, by barring courts from enjoining projects pending compliance with the statute, the bill would eliminate agency incentives to take their NEPA responsibilities seriously. Regardless of how sloppy or incomplete their NEPA analyses are, they will suffer no adverse consequences if a court finds that violations have occurred. In conclusion, now is not the right time to amend NEPA, and the SPEED Act is not the right way to do it. Thank you.